Hello property masterminders, my name is Aknella and I am an attorney, conveyancer and notary. Today I'm going to discuss some concepts which I believe sometimes as first-time buyers or investors may not be aware of. The question that I get asked is what happens when the offer to purchase has been signed or accepted. If there is an agent that is involved, the agent usually sends that offer to purchase to the conveyancer. Question is, who appoints the conveyancer? In Gauteng, it's usually the seller that appoints a conveyancer. But as you may be aware of now, this is something that you can negotiate. The buyer can actually speak to the seller directly and ask to appoint their own conveyancer, or if there's an agent involved, the buyer can also say to the agent, I need to use my own conveyancer, and this is something that can actually be added onto the offer to purchase. If there is no agent, the seller will send the offer to purchase to the appointed conveyancer, or it could be the buyer himself or herself who will send that offer to purchase to the conveyancer that they have nominated. Now, what normally happens is where I find that there's confusion, especially when there's an agent involved. In the offer to purchase, there's usually the portion where you need to pay a deposit, and there's also the mortgage bond that needs to be approved, or a bond approval. What happens is that most agents do not always ask the buyer when the deposit needs to be paid. This is very important. You need to state on the offer to purchase when the deposit is due to be paid. So if you say that you can you will pay your deposit 5 days from date of last signature, that date must actually be noted on the offer to purchase, or it must just be stated that 5 working days or 5 calendar days from date of last signature. This is usually a problem because I find that sometimes buyers don't meet those targets, and then when you as the conveyancer call them, they say, oh, I was not aware that I was supposed to pay the deposit by this date, and yet it is there on the offer to purchase. So please be very conscious of that fact and of the date that is written with regards to when the deposit is paid, because if you don't pay the deposit on the date that is on the offer to purchase, you as the buyer are already in breach. And then there is the date that is stated when a bond is going to be obtained. So sometimes an actual date is written there, or it can be said that the buyer is given 30 days to obtain a bond from date of last signature, with an automatic renewal of another 45 days. Just watch what the offer to purchase says so that you're very clear when you're supposed to obtain your mortgage bond. Okay, so now on any transaction, I'm going to be interchanging between transferring attorney and conveyancer, because it just depends on how I'm using the word. It's basically the same thing, don't get confused. So on any transaction, there can either be 1, 2, or 3 attorneys or conveyancers that are appointed on one transaction, and the conveyancer who's always on the transaction is the transfer attorney. The transfer attorney is the one that does the most work. The transfer attorney is basically responsible for coordinating the other attorneys that are on the transaction, not to supervise their work, but to just ensure that they're ready, and the transfer attorney is the one that arranges when lodgement will take place at the deeds office. So if the buyer is buying a property for cash, and by cash we know that there's no bond. If the buyer is buying a property for cash, and if the seller does not have an existing bond on their property, then there's only one attorney or one conveyancer that is on that transaction. That's the transfer attorney. They'll coordinate everything, and then they go and lodge on their own. If the buyer is going to get a bond on the property, and the seller does not have an existing bond on the property they are selling, then there will only be 2 conveyancers that will be on that transaction. That will be the transfer attorney and the bond attorney. The bond attorney is usually appointed by the bank where the buyer has got his bond. If the buyer is getting a bond and the seller has got an existing bond on the property, then there'll be 3 conveyancers on that transaction. So there'll be the transfer attorney who's coordinating everything and ensuring that that property is going to transfer into the buyer's name. There's going to be the bond attorney who's going to be responsible for registering the buyer's bond. And then there's going to be the bond cancellation attorney who is going to be responsible for cancelling the seller's existing bond. So the next question is, who is responsible for paying what? The seller is usually responsible, if they've got an existing bond, for paying the bond cancellation fees. They are also responsible for paying for the rates clearance figures and the agent. They're also responsible for the levy clearance figures if it's a sectional title. They're responsible for paying the agent's commission if there is an agent. They're responsible for the electrical compliance certificate. By this, it means that the seller has to ensure that there are no electrical problems on that property. So they appoint an electrician who goes and does an inspection. If there's anything that needs to be fixed, that is for the seller's account. The buyer is then responsible for paying the balance of the transfer costs. So if a property is less than 900,000, there is no transfer duty, and if a property is over 900,000, then there is a transfer duty. So the question is, what do each of these attorneys do? The transfer attorney, like I said, is responsible for doing the bulk of the work and coordinates the other attorneys that may be on the transaction. The bond attorney, they are responsible for the bond registration. So they prepare all the bond documents, and the buyer goes and signs the bond documents. Please be aware that the buyer is responsible for also paying for the bond attorney. Usually buyers get confused because if they get an invoice from the transfer attorney, they think that they've paid everything. No, you also have the payment that you're going to make to the bond attorney for doing the registration of the bond. It is always wise to ensure that if you've got an agent and you're buying a property, you understand what are the costs involved for the bond attorney and for the transfer attorney, because usually I've had situations where a transaction has come to me and everything is going ahead, and then when the buyer receives the costs, they suddenly freak out and say, I didn't know it was going to cost me that much. And then when they get to hear that they also have to pay for the bond attorneys, they then just say, oh, I can't do this. And usually the transaction fails. So please ensure that you understand what you are liable to pay as a buyer, which is the bond attorney's fees and the transfer attorney's fees. You can also find this on the website. If you just go onto Google and you type in transfer costs or bond costs, and you put in the purchase price of the property, it will work out roughly what you are going to pay. There may be maybe 2,000 rands extra that you may pay when that transaction goes to the attorneys, because the costs that you get on the internet do not actually include all the other little disbursements that may be included on the attorney's fees. So I hope that this is clear, but please be aware that when you are getting into a transaction and you need to ask anything, we're here to help you, and we're able to assist you and advise you on what you need to do. Thank you very much.